But I want to share with you a remarkable case that came out in the First Department 2 years ago. It was called Hill versus New York City Health and Hospitals Corporation. And get this, this is fascinating. It blows my mind to think about it. In that case, the key issue was whether a patient who appeared for a planned appointment without receiving treatment represents continuous treatment to satisfy the continuous treatment doctrine. So think about that. The patient goes to the doctor for a visit, for a planned visit. No treatment is actually rendered. It doesn't say why, but no treatment is rendered. And what does the court do? The lower court says, hey, there's no continuous treatment. Case dismissed. Your case is not timely. The appellate division, the First Department, turns around and says, wait a second. Hold on. We disagree. And here's why. The appellate court reversed and said since the patient in the hospital still had an ongoing relationship that was intended to continue forward, continuous treatment is present, and the claim was timely. So that is a remarkable case that allows a patient who might otherwise not be timely, now they are. Why? Because of an ongoing doctor-patient relationship. And now the court says, yes, even though no treatment was rendered, it was the intention of the patient to return and the intention of the doctor to have the patient return for what? Ongoing care and treatment. Very, very interesting, very important point to keep in mind as you're talking to these people to learn whether or not they may have a valid basis for a case. All right. Now, we talked a little bit about children and adults and the time frame. There are variations. Okay? The most important thing to keep in mind is, before getting into the details of any case, is when did this happen? You always want to know that question. All right. So now, when do you need a medical expert in a medical malpractice case? Can anyone answer that question? No? Okay, I'm going home. The answer is, in every single case, we need a medical expert to confirm that the client has a valid basis for a case. It's not like a car accident case where somebody claims they got injured in a car accident and the next day the attorney can go ahead and file suit. We are required to have a medical expert review all of the medical records to confirm what? To confirm liability, causation, and damages. Or, if we put it another way, to confirm that the doctor violated the basic standards of medical care. That's liability. To confirm that his wrongdoing was a cause of the injury. We don't have to show it was the cause. We only have to show it was a cause. That's the link. That's the connection. That's the causation. There must be that bridge between the liability and the injuries in order to connect the two to show we have a valid case. And then we need to be able to show that the client has significant injury. Those are the three things we have to be able to show in a malpractice case. And our expert must be able to confirm each one of those things. If any one of those elements is missing, we can't go forward with a case. So it's critically important to understand those three elements before you can tell the client, hey, listen, you've got a good, valid case. So I asked the question, in what circumstances do we actually need a medical expert? And the answer I told you was in every single case. But I should change that. It's not in every single case. It's in every single case but one. And that one scenario involves a case, and I'm going to tell you what the English version of the phrase is, and you all know what this Latin phrase is. And the moment I say it, you'll know exactly what I'm talking about. It's in a case involving, for example, a patient goes in to have surgery on their right hand. They come out with a third-degree burn to their left shoulder. Do we need a medical expert in that scenario? No. Why not? You're perfectly right. You're exactly right. So the answer is the thing speaks for itself, which is the English version of saying, there you go, you know it from law school, res ipsa loquitur. The thing speaks for itself. Does it really? What does that mean in a medical malpractice case? It means that in that scenario, where it is so obvious to everybody involved, just telling you in a few seconds what happened in this scenario Guy goes in for hand surgery, he shouldn't be coming out with a burn to his left shoulder, right? In that situation where we don't need a medical expert to explain to the jury what happened, we don't need an expert because the thing speaks for itself.